Good afternoon and welcome to Coast Legal Aid's Fridays with Friends. I'm Geraldine DeBianchi. I am the Mobile Justice Squad attorney in the Senior Citizen Law Project. Today we are going to be hosting a discussion on estate planning and advanced directives with prominent attorneys in our community who specialize in the field. I thank you all for joining us, and I'd like to give you a little background. If you all don't mind, I will read about our great panelists and let you see how much experience and expertise they bring to our discussion today. So first we have with us Nathan Nevins. He is the founder and managing attorney of Sunshine State Probate. Nathan, also known as Nate, enjoys getting to know each of his clients because the probate process requires frequent communication between the client and the attorney. It is truly a team effort to finalize the affairs of a deceased individual. The death of a loved one can be a very difficult time, and few things give Nathan more joy than helping individuals through that tough time. When you choose Sunshine State Probate, your calls and emails will be returned expeditiously. Nate has numerous accolades, including selected as Rising Star by Super Lawyers in 2018, 2019, 2020, and 2021. A top 40 under 40 attorney by the National Trial Lawyers in 2017 as well. Nathan is a member of the United States Southern District of Florida and is a graduate of the University of Florida College of Law with honors. Also joining us is Basel Zacur. Basel is the founding attorney for the law office of Basel Zacur. He is a resident of Broward County and was born and raised in South Florida. He attended Florida International University and graduated with a double major in finance and international business. After graduation, he went on to further his education and attended Nova Southeastern Shepherd Broad School of Law. He graduated in 2002 with a Juris Doctorate degree. Basel became a member of the Florida Bar in 2002. While in law school, he clerked with a firm that specialized in the field of insurance defense. After graduation, he began his career as an attorney working at a prominent personal injury and insurance defense firm handling complex litigation cases. He then began working for the 11th Judicial Circuit as a trial court staff attorney, doing research and writing formal opinions for judges in various fields of law, including but not limited to civil, criminal, probate, family, and appellate law. After 5 years, he then went on to broaden his trial knowledge and experience in the courtroom and began working for in-house counsel for a national insurance company as a trial attorney, handling a voluminous caseload, including spinal cord injuries, wrongful death, and DUI cases. He's brought many cases to a favorable verdict on their behalf. After 14 years of accumulating knowledge in various fields of law, Basel opened his own law firm and is currently specializing in probate, wills, trusts, estates, real estate, commercial law, contracts, personal injury, and general law matters. Welcome, Basel. And finally, we have with us Daniela Pretus of Kelley Kronenberg. She assists in handling matters related to guardianship, probate, elder law, and estate planning. Prior to joining the firm, Daniela worked in an international boutique law firm where she concentrated her practice on advising clients in Latin America, Europe, and the U.S. on international transactions and dispute resolution. She has extensive experience working on international contracts, cross-border transactions, litigation in state and federal court, recognition and enforcement of foreign judgments, obtaining evidence for use in foreign litigation, and international asset recovery. Daniela is actively involved in the local community, acting as a pro bono guardian ad litem for minors and participating in Dade Legal Aid's Venture Law Project for startups. She is also a member of the Junior League of Miami, which is a charitable organization that promotes volunteerism, and empowers at-risk women and families through education and leadership. Daniela earned her Bachelor of Laws degree from the Universidad Pontificia, you're going to have to correct me, Daniela, de Camillas in Madrid, Spain, and went on to earn her Juris Doctorate degree from St. Thomas University School of Law. Welcome, Daniela, and please tell us how to pronounce the name of your law school properly.
Yes, it's Comillas, but you got the rest right. It's
okay, wonderful. Yeah. Well, thank you all very much for joining us. The fact that your bios were so long tells us that you are very experienced, knowledgeable, and involved in your community, as well as in participating in the lives and preparation of estates and advanced directives for your clients. So what I'd like to do is each of you just tell us a little bit. I know I've given a long dissertation, if you will, about your background, but go ahead and tell us just real quick about your practice in general and tell us about yourselves, and then we'll move on to the nuts and bolts of advanced directives. I'm going to start with you, Nate, since you were the first on my list of the bios.
So my name is Nathan Nevins. I'm a solo practitioner, and I do estate planning. My practice is primarily focused on probate administration, so I usually handle after all the documents have been created, and I'm kind of the one who will help essentially administer these documents after the person passes. I handle probate administration all over the state, from the Keys all the way up to the Panhandle. So I have a pretty broad base of the differences in the way probates happen all over the state, because they can actually be quite different from county to county, circuit to circuit, judge to judge. So that's what I do. I represent a lot of regular folks, and I'm really excited to be here.
Well, thank you for being here. Basel, why don't you give us a little background on yourself? Thank you.
Hi, everyone. My name is Basel Zacur, and I am a solo practitioner also. Basically, what we concentrate on in this practice, or at least 70% of our practice, is basically both estate planning and probate. What we try to do in my office is give you advice with not just how to prepare your estate, but how to also avoid probate altogether. Although that is part of our practice, and these advanced directives we do suggest that you do, we basically also try to figure out a way, if we can, to avoid probate, so that way you don't have to go through the lengthy process of probate and basically sit and wait and manage the property while it's not in your name as of that point in time. So that's what we try to do in my firm, and I thank Geraldine and Coast to Coast Legal Aid for allowing me to sit here and speak along with the other attorneys.
Thank you for being here, Basel, and very good tips that we will circle back to. Daniela, how are you?
Thank you so much for this chance to speak with you guys. My name is Daniela Pretus, and I joined Kelley Kronenberg in 2020, kind of in the middle of the pandemic, when we actually experienced a lot of work in this practice area. My practice focuses exclusively on estate planning and probate and guardianship administration. And then I also handle litigation of a lot of these issues when estate plans go wrong, whether because there's improper execution or some other issue, like a will contest or something like that. And so a lot of my estate planning, tips are when I'm always kind of with a litigator hat on, trying to avoid any issues, and those are where my recommendations come from. I think we have a good group in that sense.
Yeah, I think that's important. I think you've all made it quite clear that the most important thing is to plan and to avoid, and to have the hat on, like you said, of a litigator, to avoid that in advising your clients. So before we get to everything, let me just let our viewers know that we will be taking questions. You could drop them in the comment box, and we will get to them at the end of our discussion with the attorneys. And this is also going to be one general CLE, and we'll also drop that CLE number in the comments when we've completed our discussion, and I will give that to everybody at the end. So let's get to our talk. Estate planning. For those of us who are watching right now, there is something called estate planning, and there are advanced directives. Daniela, since you're on right now, tell us, in your opinion, and you just gave us a glimpse of it, the significance of planning an estate, and then why we would prepare advanced directives, and which we'll talk about the individual ones after you tell us, in your opinion, which would, reflect a lot of ours.
In general, obviously it's, estate planning is a very broad term that's used for any number of tools that we can use to plan for these times in our life, such as incapacity or death, that may come. So something that a lot of people, a myth is that you need to have a lot of money to do estate planning. But estate planning goes beyond just having millions and avoiding taxes or avoiding probate. A lot of times it's just about making things clear to your loved ones of what you want to be, what your wishes are if you're incapacitated or if you pass away, and to take those difficult decisions out of their hands. So they already know that they're doing what you would have wanted and don't have to do that. And this includes everything from who's going to be your guardian if you're incapacitated, who's going to be a guardian for your children if you're if you pass away, and then obviously who's going to be able to make financial decisions for you, who's going to be able to make healthcare decisions for you. So if you don't plan, then the law says who's going to get your money, who's going to, is going to be the one, a judge is going to be the one who's going to appoint a guardian. And those may not be in your, in what you to believe to be your best interest. So that's, it's important to analyze your situation and determine which of those tools you're going to use to make your, the plan that's right for you and your family.
I think, Basel, you would agree with that, correct?
I would definitely agree with that. Just to expand just a little bit as far as what Daniela has said. For most people, estate planning consists of 4 documents, and that's last will and testament, durable power of attorney, healthcare surrogate, and a living will. Most of the time, people that come into my office are not the $1 million, breadwinners or anything like that. Most of the time, they're average people just like you and I, in which they request initially a will, okay? And then when I get into the details as far as power of attorney, healthcare surrogate, as well as a living will, then they realize, oh, I have to prepare for that, and that will be part of my estate. So for most people, the estate is those 4 documents. However, we do try to, like I said, avoid probate as much as possible, but those 4 documents are basic parts to an estate as far as most clients are concerned.
Right. And so, Nate, again, you would agree with your colleagues, I'm sure, and probably had a little something to add to that in terms of the inevitability that we all face, that we will not all be on this planet forever. What we don't all, we also have to look at the possibility, but not inevitability, of incapacity. So go right ahead, Nate.
So what I always tell clients is estate planning is basically an ounce of prevention is worth a pound of care. I mean, I'm sure we've all heard that phrase. Basically anything, for the most part, anything that we can do in estate planning documents can be done anyway through some sort of court process. It's just a question of, do you want to spend a little bit now to get everything all lined up, or do you want to have to go through a more lengthy court process, or your family go through a more lengthy court process in the future? So I think that it's really about just making sure that your wishes are taken care of and in a timely and cost-effective way, essentially.
I think you and Basel touched on an important point, that estate planning is not just for the rich. It's not just for people of means. It's for everyone, because if you own something or if you are somebody that may incur an incapacity in the future, which nobody could foresee, but you can plan for, then this is where the three of you and our colleagues out there that do this kind of work come in very, very handy and essential to estate planning. So let's talk about the documents that encapsulate estate planning. So I listed, and Basel spoke of them: last will and testament, durable power of attorney, healthcare power of attorney, also known as a healthcare surrogate, and a living will. Daniela also mentioned guardianship. So I will, when we get to the end, we'll let you touch on that a little bit, Daniela, because that's important for our, we have some inquiries into that too, and I'm sure some of our viewers are interested in that. And then we'll also touch on, just a bit, we'll touch on revocable living trusts at the end as well. So let's dig right in with our top document in terms of estate planning. The first question always comes, can I get a last will and testament? A lot of people don't know, like Basel said, that there are other documents that come along with this. So let's start with the will and tell us, what's the significance of this document? I'll start with you, Nate. In your opinion, the significance of a will when somebody asks you the necessity of it and the purpose of it.
So, I mean, in basic terms, a will is how you're going to direct your assets after you pass, and who you're going to appoint as the personal representative to essentially wind up your estate. So wills are very important in that it does help expedite the probate process. You still go through probate with a will. And of course, you direct who actually gets your assets. I could talk all day about wills. I mean, as I said, I mostly do probate administration, so I see a lot of wills. I see them that have been drafted by attorneys. I see ones that have been drafted by non-attorneys, you know, the decedents themselves. The decedent is the person who passed. And I also see ones that are drafted by non-attorneys or pulled off the internet that are invalid. I see ones that you have to go through extra steps to actually probate the will. And as I said, you know, I do these all over the state. So probate, which is, you know, probating a will, it varies so much from county to county, judge to judge, in that some judges in certain counties can be very, very strict with formalities. I mean, look, every judge in the whole state is gonna, the basic formalities, clearly they're gonna follow the law, but, you know, like anything else, you can get extremely picky with certain things. So not having a will drafted by an attorney that knows what they're doing can just slow everything down, to be quite honest. The probate process as is a pretty slow process. It's probably, you know, why Basel kept talking about the goal to avoid probate. I completely understand that. It's a common goal for estate planning. But if you don't have a will that's drafted correctly, perfectly, essentially, it can just slow things down even more. So
yeah. And the sad part is, when do you find out that that will is not drafted properly? 99.9% of the time.
Sure. And, you know, there are still wills that are valid, but not what's called self-proven. I'm not going to get into the weeds too much, but where you have to go through extra steps essentially to get the judge to say that it's valid. So even if the will is valid, it still can slow the process down immensely. The other unique thing about Florida is we don't recognize what's called holographic wills. So in other states, they allow wills that are just in the handwriting of the person who passed to be valid. So a lot of people incorrectly will do that. In Florida, they won't have witnesses, not anything like that. And unfortunately, it's just not valid. And that can create a lot of issues with family members that feel like they're getting the short end of the stick. You know, I can't tell you how many times a family member said, but so-and-so wanted me to have this. Here's a letter that was written by them. And the last thing that you want when a family is grieving over someone's death is to have any sort of hard feelings about where these assets are going to go. So I think
You're
wills
absolutely right.
they're the bedrock of any estate plan, and I think they're really important.
So Daniela, a potential client comes to your office and says, I want a will. What does a will mean to me? Like, what am I going to put in there? And do I need one? And you say to that client,
well, even if that client has already gone to Basel and done everything possible to avoid probate, I would say, well, between now and the time when you die, you may acquire property. You could win the lottery tomorrow. There could be assets in your name when you die that still have to be dealt with. And a will just say who is going to get your property when you die. So basically I would say, well, here's what would happen if you died today. Here's, the law says that if you do not have a will, these are the people, and generally it's, it will go to your spouse, your children, your parents, your siblings. There's an order in which that will happen. It's called intestacy if you don't have a will. And then if that is not what you want, you definitely need a will. And even if you do want, like Nathan was saying, it's still good to have one. So the will, it can name, either specific beneficiaries. It can say, anything will go to my children. It can name a charity. So it really, there's any number of possibilities of how complicated you can get. You can have a very simple will that just deals with any loose ends that you might have. And then there's a lot of things like personal property, including, everything from that can be very valuable, baseball card collections, certain things like that if you haven't actually taken the steps to change, to title them in the name of a trust or to transfer them during your lifetime, they would still be included in what's called your probate estate and would have to be dealt with that way. So that's what I would tell the client.
So Basel, client walks into you and say, but why do I need it? I put everything, just like Daniela said, I think that I avoided probate. And she said, just like Daniela said, you could win the lottery tomorrow. You could inherit money tomorrow. What are you going to do to let them know that the significance of this document cannot be overstated? And tell us when this document, because in comparison to the other documents, this document becomes relevant when, Basel, just to let everybody know upon.
It's as soon as you cross over, as soon as the person passes away, this is when the will takes effect. When I talk to my clients, I don't exactly tell them, hey, you don't need a will. I tell them you always need a will. But what we try to do is avoid as much probate as possible, but I always advise that you still need a will because, as Daniela said, you never know what's going to happen after you sign off on that will. Sometimes, like she said, you might win the lottery. You might inherit other property that you're not aware of. You might, that you're aware of, but after you sign the will. You might have a wrongful death lawsuit in which you want the personal representative to be in charge of. So there's many scenarios in which last will and testament is necessary. So even though you have, let's just say a trust that would possibly avoid having any kind of probate, you still need a will that'll basically put the assets in a trust. So overall, the will is the most important thing to direct how you want your assets to be distributed if for whatever reason we're not able to make that distribution prior to your passing. So basically the will in all these documents is probably the most important when it comes to your physical assets. Everything else is, with regard to your health, but well, except for the durable power of attorney, but this specifically is after you cross over. There's no control after you cross over. So that is how important this will is.
And lastly, I believe it was Nathan who touched on it, and you said the personal representative. Just to clarify, who are the principal parties and persons in this will? Personal representative, known in the past as the executor of the will. So there's the personal representative, and who else is involved in this will? And from there, we could move on to the durable power of attorney. You want to tell us, Basil?
Nate or Basil?
In the will. Go ahead.
Okay, well, you have the personal representative, and what I like to do is I like to explain to my clients the personal representative is basically the manager of your assets while this is going on in probate. So basically, you have to make sure if there's a mortgage on the house that is getting paid. You have to make sure that electricity is getting paid. You have to make sure that decisions are being made as to what to do with the particular assets. While it's going through probate. So that's what I like to explain to my clients. Think of the personal representative as being the manager of your assets until the probate is over and done. And then there is the beneficiaries. The beneficiaries are the people that actually inherit what it is that you are giving to them. So there is this process of probate, yes, and may take a few months if it's smooth, but during the time period in which probate is going forward, the personal representative most likely has to take care of or manage the assets while it's being probated in court.
Very good. Nate, what is the significance of this personal representative, and who should the testator or testatrix appoint?
Someone who's responsible, someone who's organized, someone who's good with communication. Ideally, they know how to use a computer. The significance is that's going to be the person who's essentially controlling everything, obviously with judicial oversight, but that's going to be the person who's controlling everything after you pass, making sure,
That's
tying
important.
up all the loose ends, essentially. So anyone who you think is physically and mentally capable of doing this. I mean, look, some of this stuff is it's a dirty job, but someone's got to do it, going through someone's house and going through all their paperwork, arranging for someone to clean out the house, all the personal property, going through their filing cabinet, cleaning, all that type of stuff. I mean, this is it's not an easy job for the most part.
No, you're right. And Daniela, I think you would agree it should be somebody that you trust, correct? You want
Absolutely.
Right.
A good personal representative, generally will try to do things smoothly and often go above and beyond in doing these like personal things like cleaning out personal property and do things well. But a bad personal representative can then, put you in a place where you're litigating or having to obtain information or having to force them to act. And then that can actually just deplete your limited assets when all you wanted was to, pass them on to your beneficiaries.
So before we move on, two things. Is there an alternate to the personal representative just in case? Go ahead, Basil.
Oh, sorry.
Well, yes, normally, normally we would request that, they provide a backup to the personal representative in case that person's not able to act for whatever reason, whether they are incapacitated or distraught or they're just not able to. We normally request a backup and list it in the last will and testament. So then that way we have all bases, and it doesn't have to be just one backup. There could be another backup, another backup. I also normally tell my clients, do not have two personal representatives. I normally advise them to have one personal representative assigned, because we do not need a situation which two personal representatives are there and they disagree as far as how to dispose of the property or assets, and then they fight amongst each other. So basically what we advise our clients, and basically with all these advanced directives, is assign one particular person, because if you have a situation which you have multiple persons in charge, then it could end up in disaster and more litigation and more cost to your estate.
I think that's good advice. I think Nate and Daniela, you agree with that? Yes.
I could not agree more. And one thing that some people don't know is that, in Florida, Florida law requires personal representatives to be represented by an attorney unless they're attorneys themselves. And so if you have two personal representatives, you could come, to a situation where each personal representative hire separate counsel, and then they need to agree on everything in order to, so you have trouble making decisions, and there's just increasing cost when, it's just important to select one person and then have a backup if that person declines. And then also something that, may seem obvious, but, think of how old you will be when you presumably may pass, and maybe don't have that person also be 90, because then maybe they're not going to be able to serve.
Right, that makes sense. And I like that you're all honing in on what you're trying to do is save money in the long run for the estate, for the decedent. You may have to take care of your will and your estate plan, but that expense, and it's not necessarily going to be a large one, but it may be, it's something to be done. It won't, in the end, it'll pay off. So I'm glad that you keep bringing that point up for our viewers. So I think now, does anybody else have anything they wanted to say about the last will and testament? We'll get back to with all of the documents, the necessity of drafting them all properly and within the legalities of Florida law, statutes, and the like. But anything else did we miss anything on the last will and testament that anybody wanted to bring up before we move on? I don't want to miss anything. Okay, so our next document for advanced directives is a durable power of attorney. So why don't you kick this one off, Nate, and tell us what a durable power of attorney is and the significance of the document.
So a durable power of attorney, in really basic terms, is with some very few exceptions, you can pretty much do anything that the principal can do. So the person that's executing the power of attorney, you're essentially letting, if you're doing a broad one, that is, they can pretty much do whatever that person signing could do. Now, you can do limited powers of attorneys. I've done them for literally just a single bank account. You can do very broad ones. Most of them are very broad. So, and what it means by durable is that when someone becomes incompetent or incapacitated, that it's still in effect. Now, I know we talked a lot about avoiding probate, but probably more important than that is avoiding the possibility of guardianship, because, probate can last maybe, the longest ones I've done are unfortunately like 2 years or so. But guardianships, I have people come into my office that are in their 70s, and, a guardianship usually lasts until the person passes. So we're talking about a court case that literally could last 20 plus years if they don't get a power of attorney in place. And you talk about squandering assets. I mean, even the most conservative, cost-effective attorney, you still got to file, annual reports and stuff like that. So, I mean, the durable power of attorney is absolutely crucial. And it's not that expensive for the most part, and in terms of saving money, you could literally go bankrupt from a guardianship case. So I mean, it's just crucial.
Yep, I have to agree with you. And Basel, if you'll tell us, in your opinion, the significance of this document and how you work it into your practice and your advanced directives plannings.
Well, normally what I advise my clients is the power of attorney is especially important for financial decisions to be made. I think we have to clarify that power of attorney is for financial decisions. Last will is for assets and properties, but assets and property. However, the last two, healthcare surrogate and living will, that's for health. So I agree with Nate in that, for financial decisions, to be made, as far as managing, your assets, especially while you're incapacitated, is a necessity. And I always recommend it. And like Nate said, it could be as broad as possible, or it could be extremely narrow and limited. So I always recommend to my clients to have that as part of their package. So then that way it could avoid, like Nate said, any kind of guardianship or court proceedings or what have you. And once again, it takes from the estate.
So Daniela, break it down for us. What's included in a durable power of attorney? What are those financial responsibilities and authorities that are given? And what, go ahead.
No, so I mean, like Nate was saying, you can make it broader or more limited, but in general, you know, the durable powers of attorney generally deal with all sorts of actions involving property, bank accounts, you know, dealing with the government to request benefits on behalf of you. But there's certain powers that cannot ever be delegated to somebody else, like the right, you know, the power to vote. Or if you have for example, if you're a singer and you have like a personal contract that involves you appearing, you know, the power of attorney wouldn't be able to exercise that on your behalf. And then there's a series of powers called what we generally refer to as superpowers that you need to have that in the power of attorney specifically and like initial them separately. And those include the power to change beneficiaries on accounts, you know, make gifts on your behalf, generally to change your estate plan, because something that happens, you know, that we'd like to, you know, reiterate that's super important. A durable power of attorney is effective as of the moment that it's signed. So if
Thank you for clearing that up.
Yes.
Yes.
Exactly.
Yes,
and in other states, they have what's called springing powers of attorney that only take effect when you become incapacitated. But in Florida, unless, you know, it falls under an exception, you know, that we're talking about older documents, but just moving forward, it, you know, it goes into effect right now. So that person that you appoint as your agent under your power of attorney will have a lot of power from today, and will, you know, will maybe be able to do things possibly without your knowledge, if you're not careful. So you have to, number one, select a very trustworthy person. Number two, ensure that the powers that you're granting them, you know, that you're comfortable with that, especially in terms of being able to change beneficiary designations, for example, on an account or an IRA, where you say, when I die, this is going to go to, you know, one of my grandkids, and they change it often to themselves, you know, like these,
right.
some nefarious workings that don't become clear until years later. So that's, I guess that those are the things to look out for. So with my clients, I always go through these special powers, and I say, you know, do you want this person to be able to create a trust, to be able to make gifts from your, you know, from your accounts, or do you want it to be more limited? And that, sorry to go on, but it touches on what Nate was saying about avoiding guardianship. So advanced directives can often be a substitute for a formal guardianship. And the law says that if there is a lesser restrictive alternative, then that should be respected. But you have to make sure that you know, there may be something that is not in your limited power of attorney that you may need a guardian and something. So you kind of have to look at that and decide what you're going to need. But it's very, very important. For example, I just to have a small anecdote, I had a case where there was a real estate closing, and there was a corrective deed that had to be signed, and we thought we were going to have to get a guardianship open, delaying the closing, you know, for possibly a couple of months until this person could sign, you know, somebody could sign on their behalf. And we realized that the daughter had a power of attorney, so they were able to sign the corrective deed on their behalf. So it does come into play very often on a daily basis, having these documents.
And that highlights the importance of what is seemingly a simple document to sign, not simple to prepare, certainly not simple to explain. And there's a lot of law that goes into it, but for that person to sign and have the explanation of a professional attorney, so that in the future, look at how easy, or making a difficult process a little bit easier because there was preparation involved. And you hit on a really important point. The relevance of this document comes into play immediately in the state of Florida. There is no springing. So I'm glad you pointed that out. And Basel, these superpowers Do you enumerate them with each of your clients and make sure that they understand them? Is that something that's important for each individual preparation?
Absolutely. They have to know exactly what it is they're signing off on. A lot of times, for example, as Daniela said, there's a gift provision in there that applies sometimes. And sometimes they're like, my clients are, well, no, I don't want them to just give my money out freely like that. And something I just want to add with regard to what Daniela said, remember, power of attorney is only while you're alive. As soon as you cross over, that's it. It's not valid anymore. So a lot of people come to my office and they say, oh, I still have the power of attorney, even though their father or mother passed away from, a month ago or 2 months ago. It's not valid at that point in time. It's only valid while you're still alive. So understand that you still do not have a power. There is no power after you cross over.
Very important point. Thank you for bringing that up, Basel. The power of attorney, as soon as somebody passes away, is no longer in effect or a valid document. Whereas it's the other way around for the will. The will becomes effective upon death. So people need to understand that. Nate, can you tell us if a power of attorney can be revoked and how?
I mean, yeah, of course. The easiest way to do it is to execute another document. Something important is that, just executing another power of attorney, if it doesn't revoke the first one, it doesn't necessarily revoke the first one. So in other words, if you execute one for son number one, and then you execute 5 years later for son number two, it doesn't automatically revoke the one for son number one, unless it explicitly says it in the second power of attorney. So I think this is actually something that I've ran into and has created issues in terms of deciding who's going to care for, the person, the principal is what they call it, in that it really is a common misconception. And you need to, if you go see an attorney to do one of these because you want to essentially change it, you need to be clear that you had a previous one and that it needs to be revoked. Otherwise, you're essentially going to have two agents, as what they call it.
Okay, so that goes to the question, who are the parties to this document? Who's named in there? Who does the naming and their significance? And are there alternates just like there were in a will?
I mean, yeah, you can have alternates. You can have co-agents, which again, I wouldn't recommend as well. Unfortunately, sometimes they want that. But the principal is the person who is signing the document. That's the person who's essentially like delegating their power, I guess you would say.
Right.
There's the agent, sometimes referred to as the attorney in fact. That's the person who is receiving the power, can essentially, go to banks and that type of stuff on their behalf. And the other thing I really want to point out that I want to be very, very clear about is this is not just a document for when someone is in a hospital bed, in the last few days of their life and things need to be taken care of. This is for, I've had people in my office that it's as simple as, they were a laborer for 40 years and their hand can barely work anymore. And they need someone to sign checks for them, a family member. So, I mean, this is not just for the very last few months of your life. This is something that, as you get older, you might just need a little bit of help. And, it's something everyone should have.
And that's important. I'm sure all of you have clients that come to you that have this power of attorney and they're going to use it so their children can help them pay their bills and write out their checks.
Right.
Not for any reason of incapacity, but because they're older and it's for ease and it makes my life a little better and be able to balance the checkbook better than just that kind of thing. Daniela, did you have something?
Yeah, that just made me think of something, when we're talking about, like you said, naming a son, sometimes someone will have an older person have one child or other family member that's close to them, or even somebody that's a caretaker that they need to help writing checks, etc. Something that happens a lot is people will add this person directly onto their bank account And that, you know, if you have a person on a bank account as a co-owner of the account, generally, unless you can really prove that that was really only for convenience purposes, but generally that person will own the entire account upon your death. So this happens sometimes where there's like one of the children lives in South Florida with the mom, the other siblings live in other parts of the country, and so, you know, Florida sibling is on all the accounts. Mom dies, and then, you know, the sibling says, well, no, mom clearly, you know, wanted me to have all these accounts. This is mine. So if that's not, you know, what you want, then it might not be a good idea to try to substitute the power of attorney by just adding somebody onto accounts, and actually make sure that you clarify what the role is, so that, you know, upon death, that will still go to your estate or to whoever, you know, to your trust, however you want that to pass.
So very important to the conversation of estate planning and advanced directives. So you detail what happens if you do this. So make sure that you're comfortable with any designations you make, whether it's in these documents or, like you said, on bank accounts. Basil, did you have something?
No, I was just unmuting because I thought it was going to be an open discussion, but go ahead.
No, go ahead, Basil. If you have anything you want to add to that, go ahead.
Well, no, and I agree with what Nate and Daniela said. I mean, this is a situation in which it takes effect immediately. So I always advise my clients, you know, make sure that this document is in a safe place, that, you know, is out of reach of anybody that you don't trust. I don't recommend that it's in all these documents, I don't recommend that it's in a safe deposit box, but I normally advise my clients keep it in a safe place where it's accessible in case somebody has to use it. So let's just say, like Nate said, it's someone that has to sign checks, then yes, that is readily acceptable. You can give it to the person, and that's not an issue. But at the same time, if you don't have a use for it immediately, it's always good to have it in a safe place and only have trust ones know where it's at. People that you trust know where it's at. So then that way, in case it gets to that point, hopefully it doesn't, but in case it gets to that point, it can be easily accessible and people can actually find it and use it for its proper purpose.
Yeah, I think Nate might have touched on that there are other forms of powers of attorney limited. You said you use those for other things. You want to just touch on that real quick, Nate, what you would use? Give me a situation and give our viewers an idea of why.
Sure.
A durable power of attorney is something that's used broadly and part of the estate plan, and that maybe you'll need a limited one for fill in the blank.
I've seen them for single bank accounts. Something that's somewhat common is you see them for selling someone else's car, like giving someone the authority to sell their vehicle. You see this in regards to like personal injury cases, or if you're essentially selling your car on consignment, essentially like an auction, you basically give a power of attorney to the auctioneer. But ultimately, you know, if you're getting older and selling a car can be an annoying and difficult process, you could give them a power of attorney to essentially transfer title of the vehicle. It really can be for any single thing, for the most part, to be quite honest.
Right. But if you have the durable, you don't need the limited, because they'll be able to handle those kind of transactions correctly.
Sure.
Okay. Anybody have anything else they wanted to add to the durable power of attorney discussion? Any examples you might have had with clients that you could lend to the discussion, or should we move on? Okay, so our next document that we find very important to our advanced directives is what is known as the healthcare power of attorney, and some know it as a healthcare surrogate. So if Basil would kick that one off and tell us, what is the significance of this document?
Well, the healthcare surrogate, as I like to call it, basically it allows for someone that you assign, I guess you could say, to make a health decision in case you are unable to. In case you are incapacitated for whatever reason, that person will make the healthcare decision for you. Now, this is not to be confused with the living will, where you're incapacitated, you're in a vegetative state, and you're asking someone in not so many words to pull the plug. This is basically for treatment, whether it's to apply for Medicaid benefits or to have a certain surgery or operation or some kind of treatment performed on you because for some reason you're not able to make such a decision because you're incapacitated. So that is the person that will make the decision that you are assigning to make that decision. That's what the purpose of the healthcare surrogate.
Okay, and Daniela, what's the difference between the healthcare surrogate and healthcare power of attorney and a durable power of attorney?
Well, basically, the durable power of attorney deals with all of the financial and property rights, and with the healthcare surrogate or healthcare power of attorney, what you're delegating is the ability to receive information and make decisions related to medical care. And just just as a point, this incapacity, we can be talking about, you could be in an accident and be in a coma, and then somebody needs to decide whether they're going to do, certain procedures on you. So it can happen to anybody. It's not just, an older person that has dementia.
Right. And when does this document become relevant? When does this kick in?
Well, generally, oh, sorry, were you asking me?
Yeah, go ahead. We'll keep you on. We'll move
there
on
will be this kicks in when there's a determination that you're unable to make those decisions for yourself. Generally in the hospital, that's in the broadest sense. A doctor will decide that you're not able to make medical decisions for yourself. One or maybe more doctors, depending on the type of incapacity that you have. For example, if you're in a coma, that's very clear that you're not able to do that. Sometimes if you're older and you haven't been declared incapacitated, then there may be a need for a medical evaluation.
So unlike the durable power of attorney, this does not become in use until necessity. Is that correct?
It's not a substitute.
Do you have an option of when it becomes valid and useful?
Well, the point is that you name somebody to make those decisions if you're unable to make them for yourself. So that does not happen until you're not able to do it.
Okay. And Nate, do you prepare your document the same way? Does it only become effective when the person is unable to make their own medical decisions, or can they designate at the time they can make the decision simultaneously with that person? How does
so generally, as long as they retain competency, etc., that any instructions that the principal gives is going to take precedence over the person you're assigning to. So if the person who the principal is saying, I don't want the surgery, and the person who you make your surrogate says, give them the surgery, they're not going to give you the surgery. So that's one important thing to point out. You have the option as to whether it kicks in immediately or not. And the really important thing about these that Basel touched on, but I just want to expand on, is the most underrated part of these is dealing with insurance companies and Medicare, Medicaid. I'm a relatively young man, and dealing with insurance companies, Medicaid, hospital administration, all that type of stuff. It's a nightmare. So, imagine doing that when you're an older individual, or you're not incapacitated, not incompetent, but just, diminished because of some sort of health issue. I'm sure we've all been there in some form or fashion.
Or simply not computer savvy.
Right.
Which makes a lot of this difficult. Right.
The last thing you want to do when you're hurting is be on the phone for an hour and a half with health insurance companies. So, that is just such an underrated part of these documents, just dealing with that type of stuff. So
this document does not in any way violate HIPAA provisions for the grantor, correct? They are giving whoever they specify, the surrogate, the right and entitlement to their medical documents and any medical information and the right to make their decisions on their behalf.
I mean, it essentially acts as a waiver of HIPAA. It's pretty much exactly what it is. Yeah.
Right. Thank you. Okay, very good. Basel, when you prepare your healthcare surrogates and your and the healthcare power of attorney, do you make sure that you make the distinction that what they're signing is not included in the durable so that they understand the significance of both documents?
Yeah, as I always tell my clients, when you're talking about the healthcare surrogate and the living will, that's more regarding your health issues, except for, like Nate said, insurance purposes and Medicare, as I mentioned earlier. However, I always mention to my clients that when you're talking about the power of attorney and last will and testament, those two documents are more for financial purposes and for assets. So I normally distinguish the two in that sense. A lot of people even call the healthcare some of the healthcare directives power of attorney for health, but I don't want to confuse my clients by saying that. I just like to say, hey, look, this is a healthcare directive. This is basically a healthcare surrogacy. And the bottom line is this is going to manage, you're assigning somebody to manage your healthcare situation. And that's basically how I distinguish the two. One is for health and one is for financial.
I think that's important because then they do get confused over both being called power of attorney.
Exactly.
And oftentimes there does have some confusion. I'm not sure. A lot of the times they'll come across our desk. We'll review both durable powers of attorney and healthcare surrogates. And sometimes in a form that is not prepared by an attorney, they'll slip in a healthcare provision in there. And it's not necessarily wrong. It's not necessarily right. But from our standpoint in the drafting, I believe that, and I think that you're all highlighting the significance that both two documents are definitely the better route to take, correct?
Absolutely.
You agree with that, Daniela?
Yes, and it's a thing, that's more of a maybe a minor detail, but you're going to be providing this document to a hospital, for example. So, I mean, there's no need to give them all this other information on the person's wishes. It's limited to what they really need to know. And just something, sometimes hospitals have their own form that you can fill out when you're going to get a surgery, just for that specific time. But so, if somebody is having an upcoming surgery and they're concerned that they don't have time to execute a document, you can ask for a form at the hospital, and sometimes they'll make you fill it out as to who will have decision-making capacity when you're, under the effect of anesthesia. But it's important to, in the long term, have this document so that for unforeseen circumstances.
Yeah, I think that's the key to it, the unforeseen circumstances. That's the importance of this document. It really is. So,
and some health insurance companies actually offer it for their clients. So some people might want to reach out to their health insurance company and see if they offer it too.
Oh, that's good to know. Yeah, thank you for that. It's a good tip. Anybody else have anything on the healthcare surrogates? Nate, Daniela, Basel? So Daniela, why don't you tell us about a living will and go ahead and tell us the purpose of that.
The purpose of the living will is to affirmatively state your desire that certain life prolonging procedures be either withheld altogether or withdrawn if you're either in completely in a vegetative state, or if you have a terminal condition. It's essentially like Basel said, either pulling the plug or saying, just don't plug me in. If I come, just don't do any measures beyond the reasonable ones. And generally, a living will include a list of specific measures, such as artificial feeding or, you know, certain types of treatments in specific cases, where you will initial and you'll say, this is something that I think is a life prolonging treatment that I don't want. This is something that I would want. And, you know, it's a very difficult conversation to have with clients to really think of that, you know, but you're really doing a service to your loved one who you've named maybe as your healthcare surrogate, that they don't have to make that decision. They know, you know, mom would have wanted, you know, she said she didn't want, you know, these procedures. She's already got a terminal cancer. She just wants, you know, she doesn't want to prolong her life artificially.
Yeah, I think there's a certain benevolence to this document where you take that burden off of your loved ones. So,
but just to make clear, you can always, even if you sign this document, you can always take it back as long as you're able to communicate. But this is what will happen if you're unable to communicate your wishes.
Absolutely. And the same for the healthcare surrogate, also revocable, correct?
Mm-hmm.
Okay.
Yes.
So Nate, you want to distinguish the living will and the healthcare power of attorney / healthcare surrogate?
I mean, they really work hand in hand, to be honest. You know, it's kind of what I was saying before, in that as a healthcare surrogate, the person you designate can't override what your stated wishes are. This is a way to state your wishes, not verbally, but actually writing it down. But I really think it's more about what you just said in terms of taking the burden off family members. And really, again, this is just such a hard time for families in terms of grieving. And, you know, a lot of times they're grieving before the person actually passes. Right. And this is just a way to take just a little bit of the burden off. And it also avoids, you know, disagreements between, oh, well, you know, mom wanted this, mom wanted that. Now you have a document saying exactly what she wanted. So I just think, and a living will is a very, very basic document. So I think it's very advised.
I agree. I think, Basel, you would agree that preparation of all of these documents, like Nate said, either the grieving process of death or just the difficulty when someone is alive but unable to make their decisions for themselves, makes each of these processes much easier on those of us who have the capacity and the authority to make decisions.
Absolutely. Correct? I agree with you 100%. But what I like to do in these sort of documents is I don't like to combine the healthcare surrogate and the living will into one. What I normally do is I have them distinguished as two different documents.
Absolutely.
And the reason why is because in a lot of situations, you know, you're looking for these documents and you're all confused and you're all, you know, nervous and everything like that. And I normally try to distinguish them and showing that this is for this purpose and this is for that purpose. That way they know exactly what they're looking for. Also, you know, from a family friend situation, and this is very important. I had a family friend not too long ago where the mother was had a terminal end-stage condition and she was in a vegetative state. And basically she had two daughters and she had a living will, thank God. And the living will specifically assigned the more responsible daughter, okay, in making that decision to pull the plug. So basically, when they go back and they ask each other, well, what would you have done? The more responsible daughter asked the less responsible daughter, what would you have done if you were in charge? She basically would be saying, well, my mom would be still alive today on the ventilator 10 years later if it was up to me. So that just goes to show you how important it is, first of all, to assign one person to make the decision, but also it goes to show you that I don't know too many people that want to be living on a ventilator artificially for the next 10 years, if possible. So it's extremely important to have this document, although it's a very simple document. It's extremely important to have this document. Otherwise, you could have situations in which families fight in court to determine your fate, even though that's not what you want. So It's extremely important. I recommend everybody to have it, and all these documents, because you don't want there to be family fights overall over these items that you could quash and put a rest to, in literally a couple of hours of work.
Excellent point. Couple of hours of work leads to much less acrimony in the future for family and friends. So excellent point. Any other living wills comments or stories? That was a really good one, Basil, and a really good point, because when she asked the sister, where would your mom be? And she should be here 10 years on a ventilator. But mom told us that's not what she wanted. So it's nice to know that we are doing what mom wanted and not what we wanted. And she made that decision. So the burden, responsibility, emotionally, psychologically, is also off of the family members. So let's touch on a revocable living trust. We don't have to get into the real meat and potatoes of this, but why don't you go ahead, Daniela, and tell us what this document encompasses and the purpose of it, and really requirements of it, if you would just go ahead and tell us.
So basically, the concept of a trust is transferring assets to a person called a trustee, who's a fiduciary and has special duties to manage those assets for the benefit of the beneficiaries. And in a revocable living trust, generally the grantor, who's the person that creates the trust, the beneficiary, at least initially, and the trustee are often one and the same. So you're essentially putting certain assets into this entity to, for your own benefit. And then often when you pass, for the benefit of your children, either to be distributed outright or to be managed in some way for their benefit. A revocable trust, as its name implies, can be revoked during your lifetime. And it doesn't have any separate tax consequences. It's taxed under your own social, as if the property was still in your name. But it does, well, and I don't know if you want somebody else to, but it can, as Basil, I think, has touched upon, help you to avoid probate if, and this is very important, if you do create a trust, it's very important to actually retitle those assets into the name of the trust. For example, if you put your home into the trust, you actually have to execute documents to transfer that home into the trust, or else, and this, I had a case where this happened, the house was meant to be transferred into the trust, and we had to do a probate, and it was, the outcome was completely different. And then just in terms of formalities, when you do have terms in the trust that mimic testamentary wishes, like a will, where when you die, the assets are going to go to your children, it is important that that trust has to be executed with the same formalities as a will. And I think maybe later we're going to touch on formalities and the importance of that, but that's something to keep in mind.
Thank you. Basil, when would you suggest a trust? When do you deem it necessary for a client?
Well, it depends on, I like to go over what my client's assets are at the time, potential future, acquisitions that they be making, to determine whether they need, a simple will or whether they need to get a little bit more complicated in the trust. But touching up as far as what Daniela stated earlier, the thing about the trust that I see being the number one issue with many clients that come into my office is actually funding the trust or transferring assets to the trust's name. Mm-hmm. A lot of people don't understand, hey, I got a trust, now what? Basically, That is correct. A lot of people fail to put their personal bank account in a trust's name. A lot of people fail to put their house in the trust's name. And then when we turn around and we say have a situation in which the house is in a trust, but there's no bank account that's in the trust, then basically what the title company is going to say is, hey, look, only way I'm going to, transfer the money upon the sale of this house is if you have a bank account that's in this trust's name, not in your name personally. So yes, we do have a lot of situations in which clients come in, they found a trust on the internet, or maybe they hired an attorney, but for some reason or another, they did not fund it. And that is, I think, the number one issue that we come across when it comes to these trusts. But like I said, when it comes to trust, it all depends on what your assets are in order for me to make the determination, or the recommendation, I should say, as to whether it should be held in a trust, or a simple will would be fine.
Nate, when would you recommend it more beneficial to have a trust over a simple will?
Well, to be quite honest, if they want to make things as simple as possible for their beneficiaries when they pass. So in other words, what I like to tell people is, for the vast majority of the people that I would do estate planning with, is there's really 3 steps here. You can do nothing at all. You can walk out my door and not sign a single document. That's going to make it the most difficult for your heirs when you pass. You can do a simple will. You can get everything you want. Your wishes will be met, and everything you want will happen. It'll just take a little bit more legwork. Court documents, court petitions, court orders, everything will be monitored by the court. So, it's kind of a middle ground. And then a lot of people come to my office and they basically say that they just want to make things as easy as possible. They don't want to go to court. They've been through the probate process, sometimes with me. And even though I make it as easy as possible, you basically have a judge looking over your shoulder for everything you're doing. So, I mean, to me, for the vast majority of potential clients and people that come to my office, it's really explaining about whether you want to put the time, effort, and money into setting stuff up now and making it a bit easier after you pass, the middle ground, or, just kind of let it fly and have your heirs handle it after you pass. I mean, people make their own personal decisions. I mean, what Basel is describing in terms of funding the trust, I mean, it's a significant amount of work. I mean, you got to go to banks, you got to execute deeds, you got to call up life insurance companies, execute documents, et cetera, et cetera, et cetera. And a lot of people just don't want to have to deal with all that. And they say, I'll let my heirs do it. After I pass, they're going to be getting a sizable chunk of change anyway. So they can do a little bit of legwork. Other people, they prefer to have a more extensive estate plan. And to me, that's the real key difference for the types of clients that I'm representing, at least.
Okay. Daniela, do you make a distinction for a trust when there are more financial means involved, or that doesn't make a difference? It's just more of the plan.
Certainly, if we're talking about an estate that might have to pay estate taxes, then you're in a whole other arena. For now, our exemptions are so high that most people, don't have that problem. But even so, yes, of course, when there's more assets, it is, because it does have some upfront costs. It's important to consider putting assets into a trust. But another benefit of a trust, when there are at least some assets, beyond just, for example, a piece of real estate or something else, is that even if you're your own trustee, generally, obviously, we always recommend that you have one or more successors that will be the trustee if you're unable to. But in the case of your incapacity, those assets are available for your benefit generally. Whereas if they're in your sole name, then essentially nobody can access your money. And I'm dealing with this now in another case where we're having trouble accessing funds to pay for the person's care who's incapacitated, and you have to get court orders and deal with banks for them to release funds. Whereas if the money's already in a trust and the trustee can release funds, for distribute funds for the benefit of that person. And even when you die, there's also still funds available, because also if you have an account in your name and you die and nobody else is named as a beneficiary, until the personal representative can actually be appointed and take over that, that account, to use it for the benefit of the estate, there might be things that need to be paid and they can't be paid, but if there's a trust that, it may be possible to still take care of those expenses, as long as the assets were put into the trust before death.
Oh, another good point of how to streamline the process and make it easier. Not easy, just easier. Okay. In the interest of time, anything else on a trust? Because I wanted to just touch on a guardianship as quickly as we can, because I know we're coming on 15 minutes and we still have a few more things to talk about. So if Daniela, you kick us off on guardianships real quick, and then Basel and Nate, if you would just give a little bit of your input, and then we'll move on to suggestions. Thank you.
Generally, just a guardianship is, a guardian is a person that's appointed to make decisions on behalf of somebody who's determined to be incapacitated. And that can be, there's guardianships for minors, and there's guardianships for adults that are incapacitated. So minors are kind of, would either, the natural parents of a child are generally their guardians for all decisions. So there's very few cases where you would be appointing a guardian for a minor, but sometimes, for example, if a child inherits a sum of money, you may need to appoint a guardian for the property of that child if they're inheriting more than $15,000, or if they're the beneficiary of a settlement, for example, a personal injury settlement. If it exceeds $15,000, you need to appoint a guardian. But moving on to kind of more the estate planning aspect, a guardian for an incapacitated person, they'll either be a guardian of the person, a guardian of the property, or a guardian for both, or two guardians, depending, it could be. If there are one or more of these advanced directives, you can often avoid the appointment of either a guardian of the person or of the property. But if it has to be appointed, it's a judicial process, because obviously we all have due process, right? So it's a process where there's medical professionals that are appointed to examine that person, determine whether they have capacity, and then a judge will make a determination based on all the evidence that they have. So it does take, even if it's an emergency guardianship that you can do, it still takes a few weeks. That's the minimum. And then the maximum, it could take, 1 or 2 months, even without opposition. And it changes a lot. Nathan, I know you practice in a lot of other parts of the state. It varies county to county as well. So a lot of these, the importance of these advanced directives, and one of the documents that we only touched upon is the designation of a pre-need guardian, where you say in advance who would be the person that you would want to be named if you're incapacitated. And that person will have preference, assuming that they meet the other requirements. There's some other requirements, like you can't have been convicted of a felony and you have to be an adult, and et cetera. Assuming they meet those requirements, they will be appointed before, your cousin Joe that shows up and wants to be your guardian.
Right. Oh, you know what? I'm really glad that you were able to kind of, sum that up nicely. Nate or Basel, did you have anything you wanted to add about guardianships? Because it's really important for people to understand that tool is available, and the ones that we discussed earlier can help either to, can I use the word avoid a guardianship, or maybe assist in, like you said, the pre-need document could assist in appointing somebody without so much judicial necessity, correct?
Well, what I wanted to touch upon, and I apologize if I don't answer the question directly, what I wanted to touch upon is Daniela's example as far as how many people are involved in such a guardianship. You have attorneys involved, you have medical experts involved, you have all these testimony going on, and all these people involved in just trying to determine how to direct your health care. Think about it for a second. If you don't want to do these documents, think about how much money alone is being expended in just hiring the attorneys, hiring the medical experts, hiring all these professionals and individuals with regard to just trying to make a determination as to how your healthcare is going to be directed. So if you take a look at these few simple documents, you can go to any attorney in town and it'll cost you a few $100s to handle these documents, or you could wait basically for all these professionals to get involved and all this fighting and everything like that to go on, and it could be in the thousands and thousands and thousands of dollars. So obviously you want to nip it in the bud and make these determinations now, because it can get quite expensive. And ultimately, I think you are the one that will pay, whether it be not just from your pocket, but also from, your waiting as far as, the situation that I gave. If this lady did not have a healthcare living will, then basically, the daughters could potentially be fighting to this day and time, and it'll put your wishes on hold too. So that's why I want to emphasize this importance as far as these documents, because it could get very ugly and very expensive for everybody.
You're right. Nate?
So
anything?
I just want to say something very quickly, which is it expands upon what Basel said, in that it's not just about the money, it's also about the privacy aspect. And that when you're talking, these are very tough situations when you're talking about guardianship, very private, personal matters. You might want to execute these documents just so that you don't have to have a judge nosing in your business, all these medical experts you've never met before. You want to go to your own doctor. You don't want this to be a court file. You don't want, and reference to guardianship and reference to probate, you don't want all your assets to be, open for the entire world to see, public record. So that's also a huge thing that we didn't really talk too much about, but it absolutely bears stating that when you do these estate planning documents, these are private matters. You can make them private through some of these estate planning documents, whereas all these people aren't going through your personal business. I know that's very, very important to a lot of people.
Very good point. So in our last few minutes, I want to discuss the importance of properly drafting these documents. And that could be as easy as us just saying, just get it done right to avoid any mistakes, mishaps, and litigation in the future. But if you all would just take a minute or two and say, this is why, I would really appreciate it. And then we'll get into any questions that we might have from our viewers. So go ahead, Basel, I'm going to put you on first.
All right. Well, I think the biggest mistake that I have coming into my office from clients when we're attempting to do the probate is or if they created their own will off the internet, is the self-proof affidavit. According to Florida law, that is absolutely necessary for it to be executed properly. So when we have a situation in which we're trying to admit the will into probate and the will does not have the self-proof affidavit, it's going to get kicked back. It's going to say you need an oath of witness, you need someone to go down to the courthouse, you need them to swear that this person signed it in front of you, and it becomes more complicated and more problematic. And not to mention, just finding the witness sometimes becomes almost impossible. So I think that is the number one mistake when it comes to these last will and testament, when it comes to finding them on the internet and executing them. I think the self-proof part is the part that people probably don't understand and is required by Florida law. And I think is the number one mistake that at least I have coming into my office when it comes to people trying to admit these wills for a probate.
Daniela.
Well, yeah, just something Basel was saying, sometimes getting the witnesses to actually go to the courthouse during COVID was very difficult. Some people didn't want to leave their house. As people get older, then they die. It is absolutely important to have a self-proof affidavit. But just in general, look, a will in Florida has to be executed in the presence of at least 2 witnesses and they all have to sign at the same time. So I had a probate where this person, got a will offline, filled it out with loving care, and then took it to a bank to get it notarized. and the bank notarized his signature, but failed to tell him that he needed 2 witnesses or give him 2 witnesses, because ultimately the bank does not give legal advice. So he just said he wanted a notary. They notarized it. And unfortunately, no matter how badly the family wants those wishes to be respected, it wasn't a valid will. And in that case, you know, the intestate laws were really not fair at all. And some people that were not close to, family members that were not close to him, inherited, and his wishes were not respected. So it's very important, you know, like I don't know which whether it was Basel or Nathan. There's various prices for attorneys. You know, there's various levels of advice you can get, but it's very important that you at least not only have an attorney advise you as to some of these documents and the importance and what's recommended for you, but that they also follow through and assist as much as possible with the execution. And because the best document is not going to be upheld if it is not properly executed. And I had another case where an attorney drafted a will and then mailed it to the client. And then, you know, it turned out that it was properly executed, but we had to litigate it. I mean, there's a lot of, you know, then you have to go get witnesses. You have to make sure that everybody remembers what happened, you know. Yeah. So that's the number one mistake in maybe trying to do it yourself. And I understand that it is a cost that not everybody can take on, but it is something that should be a priority, you know, if you at all can.
And I think, Nate, you might be able to tell us not just a will, but the durable power of attorney, the healthcare surrogate, the living will. There are laws in the state of Florida that dictate the proper execution of those documents as well. So when people walk into our office and say, I have the power of attorney, I am the power of attorney, and we have to say, no, you're not. And that's not it. This is not right. So
it's true. And you also have to remember, when you're 9 times out of 10, when you're presenting a durable power of attorney or a healthcare surrogate or living will, something like that, you're not presenting it to another lawyer. So you want that to be very clean and very orderly, because if that, even if it's very technically legally correct, if it doesn't look right, a hospital or a doctor's office or a bank, they're just going to say no for the most part. So, I mean, it really is best to do all of those as clean as possible in an attorney's office, because you just don't want to, you know, you think a bank is going to listen when you start arguing with them about Florida statutes and stuff like that? No, of course not. I mean, they're going to just say this doesn't pass the smell test. And if I could just add one more quick thing,
please.
In terms of common mistakes that I see with wills, you know, I agree with them that it usually is the self-proof affidavit, but something I see that sometimes judges are very picky about is the actual notary portion itself. You know, they won't say whether that's personally known or they produced ID. They won't say whether it was physical presence or they saw one of the 2 online notaries in the state of Florida. Basically, you know, judges will kick it back for that stuff. So you really have to.
There's a lot of overlapping law there that, you know, that we may be aware of, but others aren't. So I'm going to check and see if we have any questions in the comments, but I want to tell you all, this was an absolutely wonderful discussion. I think we really educated our viewers. You were the perfect panel to have on here. You gave us excellent advice. You have really relevant experience, and we appreciate you being here today. This was an important discussion for everyone. Thank you so much for being a part of our discussion today. We don't have any questions because I think, honestly, I think we answered everything. I think we were thorough. You all were thorough enough that you touched on the details that really needed to be refined so they understand the importance of estate planning and advanced directives. So thank you all so much for being here today. We really appreciate it. And to our viewers, thank you so much for watching Coast to Coast Legal Aid. Continue to view us on Thursdays for Legal Learning at noon, Fridays with Friends at noon on Facebook, and follow us on our YouTube, Instagram, Facebook, and you could find us on our website at Coast to Coast Legal Aid of South Florida. Thank you so much for watching. Thank you all so much for being here, and stay well.
Thank you, Geraldine.